Is Donald Trump seriously considering destroying the National Archive containing all presidential papers, not just his own? Is he seriously considering destroying presidential and vice presidential papers and not turning them over pursuant to the Presidential Records Act?
So MeidasTouch just exposed Trump's plan to potentially destroy the entire National Archives, not just his own records, but every presidential record in American history. This isn't hyperbole. Trump's DOJ issued a memo last week arguing he has the legal right to destroy everything. Let's break down why this is terrifying.
That is a question that's being asked by a brand new filing in breaking news by the American Historical Association and American Oversight, who are now before Judge Beryl Howell, who knows Donald Trump well because she presided over that criminal case involving election interference in Donald Trump in the District of Columbia when she was the chief judge. She's been assigned to the case. The Trump administration's not happy about it, have taken steps to try to remove her because they don't like her, but she's not going anywhere.
Beryl Howell oversaw the D.C. grand jury that indicted Trump for January 6th. She's seen his obstruction tactics firsthand, stripping attorney-client privilege from his lawyers, forcing testimony. Trump knows she won't be fooled by delay tactics or frivolous legal arguments about records preservation.
And she's now issued an order that she wants a response to the new motion for preliminary injunction as to whether Donald Trump is going to comply with the Presidential Records Act or not, or is he going to take a flamethrower, a blowtorch to the people's papers? I mean, one comment though. I know they're doing this in a methodical way, and I've appreciated everything the American Historical Association and American Oversight has done.
When historians file emergency lawsuits, democracy is in crisis. The American Historical Association has never had to go to court to stop a president from destroying records. The visceral language about flamethrowers and blowtorches reflects how unprecedented and dangerous this moment truly is.
But if it's true, as you've reported in your filing, that you reached out to the Trump administration and they refused to agree not to destroy things, including the National Archive, during the pendency of the case, I think you have the grounds for a temporary restraining order on an emergency basis. Because there's now a gap. The judge is trying to close the gap. She wants a briefing schedule by later this week. But still, he could do a lot of damage.
Trump's refusal to promise not to destroy records during litigation is legally devastating. Any normal defendant would immediately agree to preserve evidence. His refusal signals intent to destroy, which is exactly what prosecutors use to prove obstruction of justice.
The presidency is in charge of the National Archive. It's an executive branch. And the argument that Donald Trump is making is that, well, my lawyers, literally his lawyers in the Department of Justice, the Office of Legal Counsel that work for him, told him in a 50-page memo just last week that the 1977 Supreme Court precedent of Nixon versus the General Services Administration, which was about the predecessor to the Presidential Records Act, about President Nixon, the last criminal president's illegal tape recording of people while in the White House and his papers, millions and millions of pieces of paper.
Nixon v. GSA established that presidential records belong to the American people, not the president. It's why we have Watergate tapes, Pentagon papers, and every major presidential scandal exposure. Overturning it would create an imperial presidency with zero accountability.
They argued, well, Congress can't require me to turn over all the tapes, can't require me to turn over all the records. I'm the president. That's the legislative branch. Separation of powers. Are we done here? And the Supreme Court in 1977, which is the prevailing precedent, said no. Congress is allowed, as the keeper of all property under the property clause of the Constitution, that belongs to the people, whether personal in nature or private in nature. It's the people's papers, the people's property, and the landlord for that is Congress. And they can direct another archive for executive papers not the current occupant of the White House, for posterity purposes, to make sure they're not destroyed.
Think of it this way. The White House belongs to us. The cars belong to us. The furniture belongs to us. Trump's arguing he can burn down the house because he lives in it. The property clause makes clear it's all public property.
And so their argument, the Supreme Court's rationale, jurisprudential analytic, is that there's no separation of powers problem. Congress owns the papers pursuant to the property clause, and they're not directing that the papers get deposited in the Library of Congress. They're arguing that, or ruling that the papers get delivered to another branch of the executive like a time capsule for the future. These are the arguments that Donald Trump is raising now in his Office of Legal Counsel memo last week that said, no, that was wrong. You can do what you want with the papers. Destroy the National Archive if you want.
This DOJ memo came out right as Trump launched strikes on Iran. He knows these wartime decisions will be scrutinized for decades. Destroying the archives isn't just about hiding past crimes. It's about erasing the evidence of current ones.
While Donald Trump's in control of this apparatus, Marco Rubio was until recently the acting archivist, if you can believe it. They could do a lot of damage. And so the lawsuit was filed after this memo came out that said the Supreme Court precedent was wrong. And then you had the new filing. Now you've got the motion for preliminary injunction and this fight over who should be the judge.
Marco Rubio, as acting archivist, shows how Trump weaponizes every institution. Political loyalists now control the very records that could expose their corruption. It's like putting the fox in charge of the henhouse, then giving him matches.
See, Donald Trump's big tell, like he's got an itchy nose during, or blinks his eyes a lot, or twitches during a poker game, when he has cards he likes or whatever, is that he doesn't like Beryl Howell. Now, Beryl Howell, when she was the chief judge, she did some things in the cases involving Donald Trump's criminal prosecution.
Trump fears Howell because she's immune to his intimidation tactics. She's already ruled against him on executive privilege, forced his lawyers to testify, and handled his immigration abuses. She knows his playbook and won't fall for it.
She stripped some people of attorney-client privilege. She made them testify against Donald Trump in grand jury proceedings. She let some subpoenas get issued, and she's done some things in the Jan 6 sentencing and trials. She's done some things involving the Trump administration when it comes to immigration law, the Alien Enemies Act, his attempt to make law firms bend the knee and pay money. She's been right there, ringside to history, if you will. They can't wait to get rid of her.
Howell has been ringside to history, watching Trump's obstruction in real time. From January 6th to classified documents, she's seen how he destroys evidence and intimidates witnesses. That experience makes her the perfect judge for this case.
Well, they did that because there was a similar Freedom of Information Act request that went out by American Oversight on some of these issues, and it was handled by Beryl Howell. So who better to have the underlying substantive lawsuit than Beryl Howell? Okay, and nobody had been assigned to the case anyway. And the clerk of the court agreed and assigned it to Beryl Howell. Oh, that Donald Trump didn't like that. They're not related. They shouldn't be related. Why don't they just come out and say the truth? They don't like Beryl Howell. They want to get rid of her as a judge.
Trump's legal arguments are so weak that his only strategy is judge shopping. When you can't win on the law or facts, you hope for a favorable judge. His desperation to remove Howell exposes how flimsy his legal position really is.
Of course, when they have a judge they love, like Aileen Cannon, it's like, well, let's put everything in front of her down in Florida. So effectively, Beryl Howell has ruled already because she asked for a briefing schedule on this particular injunction hearing motion. She wants it by sometime this week. I think she's going to have them all. I think the briefing is going to be done by next week, and she's going to have them in for a conference. Now, there is a threat that they're going to destroy in the meantime. I think that's a real threat.
The contrast is stark. Trump loves Eileen Cannon because she delays and dismisses, but fears Beryl Howell because she follows the law. His different reactions to judges reveal this isn't about legal principle. It's about avoiding accountability.
That's why I would have moved for a temporary restraining order. Sorry to be a Monday morning armchair quarterback, but listen, I've been doing this a long time too. So with that, I can take some shots. I can make some comments.
The legal analysis here is spot on. When a party refuses to preserve evidence during litigation, courts immediately issue emergency restraining orders. Trump's refusal should have triggered instant judicial intervention to prevent ongoing document destruction.
Now, presidential and vice presidential records, any records of the government, supremely important. Freedom of Information Act requests go to government entities in order to get information. Many times from a Freedom of Information Act, a FOIA request later is filed a very large lawsuit. You know, sometimes from the outside, it's so opaque that the lawyers and the organizations are like, we think these two things are going on.
FOIA requests exposed Watergate, Iran-Contra, and the Pentagon Papers. The My Lai massacre, CIA torture programs, and NSA surveillance all came to light through records requests. Without preserved documents, government accountability dies completely.
Because if Donald Trump had his way, the whole National Archive would be set aflame. Here's what she told me during an interview yesterday about the purpose of having a Freedom of Information Act records request at the beginning of a case, and how as the administration continues, the longer it's in office, the more these information requests for records are so important.
Trump's timing isn't coincidental. As he escalates with Iran and potentially other conflicts, he wants to ensure no records exist of his decision-making process. Future historians and prosecutors must never see how these life and death choices were made.
So here's the argument that they raise about Nixon versus the General Services Administration from 1977, which is the prevailing precedent. They say that under it was on page 2, that the legislation, which was the predecessor to the Presidential Records Act, does not violate the separation of powers, including because it does not impermissibly interfere with the ability to carry out its constitutional functions.
Trump's DOJ is brazenly misreading Nixon v. GSA. The 1977 ruling specifically said Congress has authority over presidential records under the Property Clause. Trump's lawyers are essentially arguing the Supreme Court was wrong for 50 years.
We're talking about papers, not interference with functionality. Even if they're right, which they're not in the White House, that Nixon versus GSA was wrongly decided, inviting it to be redecided by the new United States Supreme Court.
This is a calculated strategy to get the current conservative Supreme Court to overturn Nixon v. GSA. If successful, no future president would ever have to preserve records. It would be the end of presidential accountability as we know it.
The Presidential Records Act is still on the book, and it is constitutional. Congress has clear authority to enact, they say on page 2, the Presidential Records Act under the Property Clause of Article 4 of the Constitution, which the Supreme Court has held affords Congress power over the disposition of government property, sole power, both real and personal. The Office of Legal Counsel remarkably ignores this source of constitutional authority, even though it was the primary authority the Department of Justice relied upon in defending the Presidential Records Act predecessor in the court.
The hypocrisy is staggering. Trump's own DOJ previously defended the Presidential Records Act using the exact same Property Clause authority they now claim is invalid. They're literally contradicting their own legal positions for pure political gain.
The court should grant a plaintiff a motion for preliminary injunction as follows. An injunction that all defendants and their employees are preliminarily enjoined not to destroy and preserve in the custody of the federal government presidential or vice presidential records. All defendants and their employees are preliminarily enjoined not to create or send a presidential or vice presidential record using a non-official electronic message account like Signal. See, this was the very thing they told the judge.
The Signal messaging ban is crucial because Trump's team has been using disappearing message apps to avoid records requirements. They learned from Hillary's emails controversy, but in reverse. Instead of private servers, they use apps that auto-delete evidence.
Tried to get the other side to agree not to burn down the house while this case was going on, and they refused. See, I think that gets you into court a lot faster. And don't use a Signal disappearing app for your messaging unless you connect it to something that can be saved and salvaged. And then let the court know if you're destroying anything. That's a pretty good injunction. This is going to go fast.
Even Nixon preserved his tapes during Watergate litigation. Trump's outright refusal to preserve records during legal proceedings is unprecedented. It shows consciousness of guilt and intent to obstruct, behavior that would land any normal person in prison.
Beryl Howell, in her order, she ordered that there be a briefing schedule this week, set up this week for the future. I think she'll, one way or the other, she'll tell the Trump administration they got a week to answer. I think before April is done, she's going to rule. And I don't think it's going to be in favor of Donald Trump and the Trump administration and the violation of the Presidential Records Act and or the seminal case 1977 of Nixon versus the General Services Administration.
The timing matters enormously. If Howell rules against Trump during active military operations with Iran, it exposes his real motive, hiding wartime decision-making from future scrutiny. Every bomb dropped, every life lost could vanish from history.